Friends, here we are again, talking about the Supreme Court and how it was bought and sold, and it is selling out people every single day, it seems like. Today, we have a few cases that are going to be rounded up for you, talking about race-based considerations or affirmative action in schools. We're going to be talking about student debt, LGBT rights, and, good old democracy as a whole. In what I think can be described as the Supreme Court battling democracy, battling the freedoms that every single person in this country should hold fundamental to themselves. And of course, going after people that should be of a protected class in this country. The Supreme Court is at it again, and Tyler's going to jump into our first case for us right now. Tyler, what is going on with the Supreme Court? I heard a few things about them in the news. Maybe you want to just jump into a little bit. I mean, we don't hear too much about the Supreme Court. It's not like they're evil or anything.
Yeah, it's not like they've been all over the news these past few weeks. Well, let's start with the good stuff because there's not a lot of it, so we might as well get that out of the way first. We did get a handful of not so terrible SCOTUS decisions, specifically around voting rights and the future of our democracy. So let's try to rapid fire through them because they're a little bit similar, some of them. So the Supreme Court kind of unexpectedly upheld parts of the Voting Rights Act of 1965, specifically a provision that prohibits racial gerrymandering. So let's look to Alabama first. The court ruled that in Alabama, a state where there are 7 congressional seats, but 1 in every 4 voters is Black, but there's only 1 minority district, okay? They ruled that they have been denying African-American voters reasonable chance to elect a second representative. So they're expanding to 2 minority districts in the state of Alabama, which is long overdue. So yay, voting. And then in Louisiana, the Supreme Court also ruled that allowed the Louisiana congressional map to be redrawn to add, again, another majority Black district. So these are 2 heavily gerrymandered states. They have been basically since their inception. And so it's good to see the Supreme Court standing up to at least this specific provision of the Voting Rights Act. Let us not forget, however, that in 2013, they struck down a lot of other provisions of the Voting Rights Act. So we're not super happy for them to eventually do the right thing, but I guess a broken clock can be right a couple times a day. Then we've got Moore v. Harper, which is in North Carolina. The Supreme Court decided that North Carolina Supreme Court has the power to strike down the legislature's illegally gerrymandered congressional maps for violating the North Carolina Constitution. So the big thing with this case is that it rejects this super fringe theory called independent state legislature theory. Independent state legislature theory is a radical interpretation of the Constitution in which right-wing Republicans think that state courts and state constitutions are powerless when it comes to federal elections. This comes back to the big lie, 2020 election stealing stuff that they love to do so much. So we're glad to see that the court said, no, that literally doesn't make sense. And checks and balances exist for a reason. And state courts do have a say in federal elections because that's how it works. However, there are still loopholes. There are still things that could go wrong. And so I would love to hear from either of you on how you feel about this mostly good news. I'll jump to Michael first.
Yeah, I mean, I just wanted to underscore how we got here, why Alabama and why Louisiana thought that they could get away with violating the Voting Rights Act is that the court had previously signaled very strongly that they were ready to throw the whole thing out. And so in the last round of redistricting, Alabama and Louisiana, 2 states where old Jim Crow was very strong in the past, just went ahead and violated what had been longstanding precedent, longstanding law. And this was a real open question about whether or not the court would take action to completely gut what was left of the 1965 Voting Rights Act, and they didn't. And the fact that that was kind of a surprise is bad. It's a real commentary on where things stand.
That's completely my reaction too. Is just like, it is so up in the air. Like, are they going to take away voting rights? Are they going to seriously allow gerrymandering at this level to continue? I mean, that is my reaction to this. Is just, it's one little surprise that they did something good, but of course it's coupled with all the bad stuff that I think Tyler's going to jump into now as well.
Well, yeah, it's like the good and the bad. The good news is, this sets us up pretty strongly for on a strong foot for 2024, right? We just had a whole presidential election that was marred with election conspiracies and fears of electors voting for people that their constituents didn't vote for and things like that. So it's good to see the Supreme Court putting their foot down and saying no. That does not mean that Republicans will not find some new, fun, inventive way to try to break our democracy. We just have to be on the lookout for that next. But as we head into 2024, these rulings are a net good, a net positive. And so we'll do a quick cheer, but with the world's tiniest clapping violin, because when it comes to race, the Supreme Court did not always get it right. And we are now going to talk about the affirmative action case that came from North Carolina, University of North Carolina and Harvard. The Supreme Court struck down affirmative action programs. Basically, this overrules a 2003 decision, which established that the University of Michigan could consider race in its admission process. Now they've doubled back and said, no, you can't do that. It's pretty messed up. You see Justice Thomas saying we're in a post-racial world and the white youth of today shouldn't be punished for the crimes of their ancestors, things like that. And then we have, rightly from Justice Ketanji Brown Jackson saying in her dissent, deeming race irrelevant in the law does not make it so in life, does not make it irrelevant in life. This is a pretty disappointing decision. A relatively unsurprising one. But one thing that I want to talk about is that two of the people that voted in this decision to roll back affirmative action are beneficiaries of affirmative action. It's very well known that Justice Clarence Thomas benefits from affirmative action. Justice Amy Coney Barrett, white women, we've seen time and time again, white women are primary beneficiaries when it comes to affirmative action, more so than any other marginalized group. So when we see them making decisions like this, it is not in the interest of people. It is not in the interest of people who look like them. It is in the interest of, wealthy donors and ultra right-wing conservative lawmakers who, only want their children and their legacies to continue on in Ivy League institutions. And it makes me sick to my stomach. Rhett, any thoughts?
Yeah, Tyler, you used the word legacy in your discussion of this. And I think it's so important for us to remember that legacy-based admissions are still allowed at so many prestigious universities in this country. So if they're good old great-great-grandpa went to this school, you are really boosted in your admissions chance to this university. So that's very much allowed. And of course, the generational wealth that comes with a prestigious education such as that. And yeah, it's just a very frightening set of circumstances as well, because as you mentioned, these two Supreme Court justices, Coney Barrett and Thomas, they do benefit from affirmative action, and then they slam the door shut behind them in such an unsurprising yet, of course, disappointing way, that they would just climb the ladder and then throw it down behind them so nobody else can get up that ladder as well, which is just so beneficial and important to making our society more justified.
Absolutely. And I think we'll probably segue this into student debt, but I also want to quickly mention too, Black women are the most educated demographic in this country. We're seeing the rates of white men who are enrolled in college at all-time lows and continuing to go lower and lower. And so we're seeing in real time how the court is, making policy from the bench kind of to say, here are the people that we want to go to school. And it's important to note, and I don't have time to get into this, maybe we'll have to make another episode. It's important to note they made an explicit exception for military schools and military universities. And so they are clearly saying you can judge based on race when it comes to who can serve this country and what ways you can serve this country. But when it comes to serving yourself, Black and brown Americans, we will not let race become a factor. So that's a whole other thing that we can get into. But segueing into the whole larger student aspect, we got some bad news on student debt literally 20 minutes ago. So Michael, what is it?
Well, bad news on student debt. It's pretty easy to understand. Last year, President Biden put into effect he signed an executive order canceling the first $10,000 to $20,000 of student debt for people who qualified based on income. It was clearly authorized under the HEROES Act, also under the Higher Education Act of 1965. A lot of good stuff happened there. LBJ. But what the court decided was, even though the plain text of the law is gives the president the authority, and so that goes back to the way that this court operates, which is this bizarre Calvin ball where they work backwards from the outcomes that they want, and sometimes they'll apply what they call textualism, where they say, well, what does the plain text mean? And sometimes they'll apply originalism, where they'll say, what did the founders really intend when they were writing this, and try to extrapolate how how the 1780s would have interpreted whatever's going on. And sometimes there's this new one that Justice Roberts loves called the major questions doctrine, which is basically but for text. So the HEROES Act says during a national emergency, they can, the Department of Education is free to eliminate student debt, to cancel it, to modify it, to delay it, whatever. The same authority was used throughout the coronavirus pandemic. And what Justice Roberts said, and what 5 other justices signed on to, was, I don't think that's what they meant. And that's it. So that's the whole thing. Now, what is Biden able to do from here? There are a few different pathways, and apparently he's going to be announcing some kind of actions this afternoon. So fingers crossed that he watches this first. He could cite the Higher Education Act of 1965, which gives which basically set up the modern student higher education funding system that we're all sort of living in, which gives the secretary total authority, the education secretary, total authority to modify, cancel, or end loans. I think that Justice Roberts will probably have major questions and say, I don't think that's what they meant. But it's another thing that Biden could do to fight. We also obviously have a much longer issue with funding higher education separate from the student loans, because that works retroactively to people who already have loans, but it doesn't do anything for people who are enrolling in college next year, who will still pay exorbitant debts. So Bernie Sanders and Pramila Jayapal have a College for All Act that would basically be like Medicare for all, but for college. So I think we have to look at both of those, and we have to look at ways to rein in this out of control court that's acting as a super legislature with lifetime appointments.
Absolutely. It's a lot to think about. And I know for a lot of student borrowers, it's also a really scary time because we're being told this and now we're on the clock. Student borrowers have, what is it, like 30 days now that the decision's been dropped before student loan moratorium ends, and you're expected to begin repaying your loans. Interest is starting as well. And so it's a very, very stressful time, I think, for borrowers, and especially when we had so much hope that, not necessarily in the Supreme Court, but definitely in the Biden administration and the work that they were doing to, make real change for students who have been saying for far too long that this system is not sustainable and that we cannot, live in a country that demands higher education but doesn't help you pay for it and then saddles you with debt, basically until you reach your grave. So that's fun, and we'll keep looking out for that, and I'm sure we'll have a lot more to talk about on that. Yeah.
Yeah. Well, one more thing, since you mentioned the resuming repayments, it's been 3 years since anybody had to make student loan payments. And during that time, because our financial system is a bizarre web of interconnected bureaucracies, many of the loans have been bought and sold. And so people will be resuming payments with entirely different entities, and it's 40 million people who have to do this. It's a bureaucratic nightmare waiting to happen, and I'm sure that's something we'll have to be watching, so that we can say I told you so next month when the resumption is a disaster.
Michael, that is a really good point. So as someone that is getting ready to pay student loans for the first time, living the good old American dream and just thinking one day I get to pay my student loans, so exciting. I'm telling
and
all
not
my
to mention
friends,
like record
though,
high inflation and all that good stuff. Just a little treat on top of
just
all
a little
of that.
treat, just like sprinkles on top of it, of just like sprinkles of despair. So I'm telling all my friends though right now, take the time, learn who the servicer is, learn about like your income-based repayment plans. It's called IDR, income-driven repayment plans. And I actually signed up for one of those. I'm happy to say it was fairly easy. I called my servicer Mohila, who was actually named in this case, but did not want to represent themselves in like the conversation of standing. Like these people stood on behalf of them. all of this trash that's associated with it. But the representative was very empathetic on the phone, and they were able to help me sign up for one of these plans, which is going to help me like keep the interest rates under control. Doesn't make a whole lot of sense to me, but at least that is an option. So I think just like in terms of assessing options, that is one of them. And I think this also just like kind of all ties into the picture of like these Supreme Court justices, all extremely wealthy. They do not know what like a $10,000 break looks like for the average person. They don't know what $10,000 like that is like a monumental amount. That looks like months of savings, if not years of savings, and of course with interest on top of that too, for so many people in this country, and yet they couldn't afford just even a small break to the students of America. It's really a sad time for students across the country, but
And I think we've got one more case. Yeah, I think we've
Yeah,
got one more case to
one more
talk
case that
about.
came down this morning. That is total bullshit.
yeah, so I was drinking my coffee this morning and I read on Twitter, do not talk to any gays about student loans today. Because we also got a ruling about LGBT rights. And this came with the case 303 Creative LLC versus Elenis. And so this is about a Colorado-based graphic designer that did not want to design a website for a gay couple, a gay wedding, and just there's so many things that are so weird about this case. Firstly, I'll jump into the ruling, which they basically sided with the website designer, saying that they did not have to make this website, citing that they don't have to go against anything that would go against their First Amendment rights, which is just so weird because, of course, LGBT, that is a protected class in this country of people that should be protected from discrimination. But really, it is just such a scary place to be because now guess what? LGBT people can be discriminated against from businesses, just like that. Thank you to the Supreme Court. Really, just like a scary situation, but I really love Justice Sonia Sotomayor's dissent in this. It was a very strong dissent, and she was joined by Justice Kagan and Justice Jackson in what was just a like the liberals of the court versus the conservatives, the liberals standing up for the rights of gay people in this country, in complete adversity to the conservative majority on the court.
I also think it's really important to note this is probably the dumbest of all of the cases we've talked about in terms of their ruling. Seriously, like this is just the stupidest of all of them. The person who brought this case to the Supreme Court, the website designer, has not ever designed a wedding website, has not been solicited to design a wedding website for a same-sex couple. So this entire case is built on conjecture and it's built on hypothesis, something she has not been asked to do by anybody. Nobody wants your little ugly website, okay? And then they are basically saying, okay, we just said that you can't look at race when it comes to admissions, but you absolutely can discriminate based on sexual orientation when it comes to building websites or giving people services in the long run. So it's very clearly showing the court's hypocrisy, especially since both of these cases came out within like a day of each other, or these decisions came out within a day of each other. And hearing that an actual real case that has real world implications, i.e. affirmative action and its impacts, versus a totally made up website case that will now have very real world impacts against the LGBTQ plus community. It's just really wild to see. And I cannot stress enough how blatantly this shows that this court is just so unserious about anything other than just getting what they want pushed through.
Yeah, and I feel like we just hear so much about judicial activism being tied to liberal justices. Like when I learned about quote unquote judicial activism while I was in high school, I remember like the context of it was always tied to like the teacher talking about like the liberal justices on the court historically. But like now when we think about judicial activism, like it is absolutely tied to these issues that Tyler just mentioned of affirmative action and these protections for gay people. Like it absolutely is the activism of the court to dismantle these protections that are so fundamental to living in a justified society. And I want to pass it over to Michael too, because I saw his eyes light up. And so, Michael, what are your thoughts on this?
Well, I mean, it's the bottom line is that the Supreme Court is a political branch, right? They are making laws, they're doing things, they're made up of people. Many of them are people who have been bribed by billionaires. Um, and the court is already politicized. So yesterday, Biden was on TV talking about how he didn't want to expand the court, didn't want to add more justices to rebalance things out after right wing campaign to steal seats, because he was concerned that then the court would be politicized. But the court is political right now. It's making law from the bench. And in the past, for a very brief window in like the 60s and 70s, the Warren Court did a lot of the same things as a political body, but it was using its powers for good and advancing equality and moving our country forward. And now that the Democratic branches are much more likely to be controlled by people who represent the majority, the right has holed up in a foxhole of the Supreme Court. And it's an intractable problem unless we're willing to actually admit that it's a problem and do something about it. So, ball's in your court, Joe.
Absolutely. I think that's a great note to end on, honestly. We just got through a lot of stuff. The state of the Supreme Court is a little crazy right now. Gerrymandering is out. Discrimination based on race is out. Discrimination based on LGBTQ rights is in. And apparently you can only have your debts erased if you are a justice on the court. Other than that, good luck. You're on your own. So we'll keep you updated as we hear more from the court and the implications. Hopefully we'll hear from Biden soon about the future of student debt forgiveness. And we will see you next time here at Progress America Unfiltered, everyone. Goodbye.